Hi, thank you for clicking this video. This is Batok with Ola. My name is Mujola Olu, and I just briefly want to talk about the doctrine of actual and constructive notice and how you should understand them in the most basic form. Now, actual notice means that you were actually notified, just as the name or the concept or term implies. So maybe you were served a letter, you were served a court process, something was handed to you or given to you personally to notify you of an existing state of things. That's actual notice. Constructive notice just means that maybe the information was put out in the public, or there were some acts that were done that were publicly accessible and understandable or viewable, and the court would then construe everyone to have constructive notice that, oh, you already know, you saw the news, you already know, you read the newspaper, you saw that they were doing such and such overt acts. So you should have known that this is what is going on. That's constructive notice. So it means that you should construct the notice in your mind. I'm just joking. What it means is that the court will construe you as having been properly notified because some things have been made public. For instance, when dealing with a company, you are deemed to have constructive notice as an outsider dealing with the company, because the companies have registered companies, limited liabilities, for instance. They have memorandum and articles of association. So those are public records. So the court would assume that if you're dealing with them as an outsider, you should access these public records, their articles and memorandum of association, and you should go through them and understand what they contain. This will give you the information you need about the company. So you cannot come and claim that you did not know what the company was about, before the court, because you should have looked at these things. You have constructive notice of them. Now, actual notice will be that you were presented documents, informing you as to the actual state of things. For instance, if the government wants to construct a bridge or a road in front of your house now, actual notice will be that they served you a letter personally saying that from this time to this time, there will be obstruction because we want to construct a road, a bridge, and so movement will be like this, like that. That's actual notice. Constructive notice would be that they ran a television ad or they put it in the newspaper that from this time to this time, government will be constructing a bridge or a road in this place. So everyone should take notice of it. So you cannot come later and say that you did not know, because that information was put out to the general public, which you're a part of. So essentially, what constructive notice means and how it differs from actual notice is that you are not personally notified, but you are deemed to have notice of the state of things, because the information is not exactly hidden and the other party has not made any efforts to actually hide them from any reasonable person. So the test is that of a reasonable person. Oh, any reasonable person is supposed to know that this and this is going on, because they should have done this and this checks and searches and looked for this information, accessed this record, to know what is going on. So you'll be treated as such. Have you done this as well? Did you access the records? Did you ask the right questions? Did you see what you're supposed to see? Another instance would be that maybe you go to an open lot of land and you find that builders are actually building something on the land. Maybe someone wanted to sell you the land. You got there, you can find that construction work is ongoing. You are deemed to have constructive notice of the fact that the land actually belongs to another person who is already carrying out works on it. So maybe if you purchase, so for instance, you purchased the land now and you're claiming that you had no idea, nobody showed up, or you weren't issued any papers to the effect that someone already owns it and is already building on it, the court would deem you to have you'll be deemed to have had constructive notice by the overt acts of construction that you saw on the land, even if someone else tried to pass it off as theirs and tried to sell you a defective title, which you did not know was defective at the time. The fact that you saw that someone was building on the land and it was not the person trying to sell to you, and you did not ask questions or make findings, would work against you. Now, actual notice would be that maybe when you got there, another person now shows up and says, I'm the owner of this land, I'm the one doing this construction. These are my land documents, this is the proof that I am the owner. So that would be actual. They're actually notifying you that they have an adverse claim to the land and you should not buy it. But constructive notice would be that you saw it with your own eyes. So why would you go ahead and buy something like that? So this is how to easily understand the difference between actual notice and constructive notice. That's what I want to talk to you about in this video. I will see you in my very next video. Don't forget to subscribe to those.